everybody can hear me, but we are letting people in. We will start a few minutes after because we have a problem with people joining. So just a little more time. Set a time for 2:30.
Okay.
We'll call everybody back. Everybody got that message, but I will be back. We'll announce further as we go.
I'm ready when you are, so that's fine. Yeah. And then, so then we'll take a break, sort of just after 3:30. Is that okay? Say 3:35.
That sounds good, yes.
Okay.
We'll be starting at 2:05 because of the just allow everybody to join. You opportunity to drink it and about the presented the punctual. We are all starting at 5.
Hi all, it's now 2 o'clock. Yeah, just to repeat what Stan was saying, we are going to just wait for more to join. It's only less than half of the attendees have already logged in. So just 5 more minutes and then we'll get going. Yes. Peter, today should be a 3-hour webinar, so it should end about 5 o'clock.
We will start in 1 minute. This is one group, where everyone counts. So we very happy to have you here this afternoon. Happy to have Professor Jackie Arendse, who needs no introduction to. We always look forward to these sessions. So thank you for joining, and Jackie, if you want to start momentarily, but we're ready for you. The floor is yours.
Great, thank you so much. Thank you, Stan and Danny, and good afternoon, everybody. I hope you can hear me okay. Yeah, it's great to be with you this afternoon. End of May, almost the end of May, and yeah, heading very quickly into the middle of the year. And yeah, so this year really is disappearing very quickly. It's been quite an interesting year from a tax perspective, I'm sure you will agree, and not just tax, but of course, I mean, I'm thinking especially of the budget speech, and the budget speech cuts into all aspects of finance, business, etc. But especially for us tax people, I think the budget speech is something that is particularly of interest to us. And yeah, that certainly has been quite a saga, but it looks as if we finally got a budget that will be overall supported, and looks like that will carry through. I think the appetite to keep fighting is wearing off, and it looks like this will now go through. And so what we have now, of course, is just the increase in the fuel levy, and they refer to it as an inflationary increase. Nonetheless, it's an increase that wasn't there before, and that's going to come into effect next Wednesday, right? So that'll be the 4th of June. So yeah, as far as the budget is concerned, that has been quite an interesting saga. Of course, we still are in a situation, and especially because the movement in the budget between budget version 1, version 2, version 3, we also saw that the expectation around the growth in the economy, the GDP growth, significantly reduced from about 1.9% growth in 2025, 26, down to now about 1.4%, 1.4, 1.5%. That's a significant reduction. And so less growth in the economy, of course, means less tax revenue that is produced, because you need a growing and thriving economy to produce tax revenue. And so what that means is that, also taking the VAT increase off the table, which of course might have had a negative effect in terms of reducing the economy so much that it could have actually resulted in less VAT being collected, who knows? But just to carry on with the point that I'm making here, is that less tax revenue means that we're going to have even more of a deficit than was originally on the table. But now it seems that the ball is in SARS court, and it's all sort of waiting to see what SARS is going to do. And so I think we can expect to see, and there's been plenty of announcements around this, even from the SARS commissioner, that they have been allocated some more resources, and they're going to focus this a lot on remedying non-compliance, collecting outstanding debt. And wow, there's certainly a lot of outstanding debt sitting on the SARS books. You just have to, if you want to have a look at last year's annual report, you'll see they report on their debt and old debt that they are busy collecting. Obviously, some of that debt is subject to dispute, but there's still a lot of debt to be collected there. And SARS reckons they could collect, between an extra 20 to 50 billion over the next tax year, if all goes according to their plan. Now, of course, that's going to have implications for the business community, the tax advisor community, because it means that we could probably see SARS getting more assertive, aggressive, call it what you like, in terms of collecting taxes, and of course maybe slowing down on refunds. And I think especially with VAT refunds, we've seen in the past sometimes that it can be quite difficult to get SARS to pay out those refunds. We're also seeing SARS applying set-off, and one of the cases we deal with today is looking exactly at this aspect of set-off, setting off a tax liability, often an income tax liability, against a VAT refund. So yes, we're seeing all of these things being utilized by SARS. And as we go into today's presentation, you'll see a lot of it is focusing on tax judgments, because that's pretty much where all the movement has been, where all the news is sitting in the tax world for this part of the year, is in tax judgments. I think SARS has been pretty much involved with this whole budget process, so we haven't seen a lot of new interpretation notes and things like that coming out from SARS. What we have seen are these tax judgments coming out, and I see Q&A. Mark is making the point that he's already seeing VAT refunds being held back for no reason. So yeah, thanks for that observation. And I think we're probably going to see more of that type of thing. Now, so I think it is going to make our lives challenging, and especially the lives of people who are mediating in that space between taxpayers and SARS. And so a lot of what we're focusing on today with these tax judgments, I think as I just run my eye down, pretty much all of them are dealing with tax administration in some form or other. Most of them pure tax administration matters. Others, there's aspects of tax administration that come in. But, I think what it really is highlighting is that in the dispute space, a lot of that dispute is revolving around the administration of the tax law. And of course, that's SARS' responsibility to properly administer the tax law, whether it be VAT, income tax, etc., etc. And of course, we have the Tax Administration Act that sets out rights and obligations. We also have the Constitution. We have the Promotion of Administrative Justice Act to protect taxpayers' constitutional rights. And I think as we move into this space where SARS is really seeking to show what they can do in terms of additional tax collections, it is going to become very important to know your rights as taxpayers. Because we all know, especially in the dispute resolution space, there's often problems in terms of SARS not complying with deadlines, etc., etc. And yeah, this can be very challenging for taxpayers. And if you are going to fight, you need to know the rules of the game. Okay, so and inevitably, you do end up with some or other tussle with SARS, and so it is going to be increasingly important to understand the rules of the game. And so we are certainly going to see a lot of this demonstrated in the tax judgments that we are dealing with today. But before I get too carried away, let me just mention that we will go for about an hour and a half. So until, let's say, 3:35, okay? 3:35 will be the tea break, and we'll take... we'll see how we're going time-wise, but probably a 15-minute tea break, and then we'll carry on, resume at 3:50, and that'll take us through until we'll finish no later than 5 o'clock, maybe even a couple of minutes before. All right, so that's the program for today, and we're going to run through these tax judgments. You can see we've got 2 from the Constitutional Court. Increasingly, we are seeing tax disputes going through to the Constitutional Court. We're seeing some very interesting outcomes there. Yeah, some very interesting ones coming out today. The Medtronic case that involved a VAT and a VDP issue, and then of course this case with United Manganese and 4 other cases. So it was 5 cases all put together and all taken to the Constitutional Court at the same time and all heard together. And that's around this whole question of a Section 105 review, Section 105 of the Tax Administration Act. So very important principles coming through there. Then we have a look at these 3 cases from the SCA, 3 cases from the High Court. There have been quite a number of tax cases coming through the tax court as well. We just don't have time to talk to all of those, but some quite interesting cases coming through the tax court as well. And towards the end of today's presentation, we will talk about recent SARS documents and notices. And included in that, I will talk about the notice that was published on the 23rd of June, so last Friday. SARS basically publishing the notice to launch the tax filing season for 2025. Now, it hasn't opened yet, but the notice is the forerunner, because that tells us who has to submit tax returns for the 2025 year of assessment, and that notice now being published. So we'll talk about that notice under the SARS documents and notices. Right, so this is what we're going to be talking to today, and if you do have any questions as we go along, you're very welcome to pop them into the chat box. I will have a look every now and again, and either Stan or Danny, if I do overlook a question, please interrupt me and get me back on track, because I'm going to be getting very involved with these cases. But I will keep an eye on the chat box, so if you have anything that you want to ask about, you are very welcome to pop your question into the chat box. I would just ask that you just keep it onto the topic at hand. Okay. All right. So here we go. So let's start having a look at the Constitutional Court judgments. Now, interestingly, this Medtronic case, the Constitutional Court judgment actually came through even towards the end of last year. So you will see the date here. The judgment was actually handed down 20th of December 24, but it was only published sort of early 25, but it's an important one and it's an interesting one. So I thought, well, I'll talk about it because we didn't cover it in our year-end update last year. So the Medtronic case, now, some of you might remember this case going back to the SCA decision, because this is an appeal, basically. And notice it's SARS taking this matter on appeal, okay? SARS taking the matter on appeal to the Constitutional Court, and that's the appeal against the 2023 SCA judgment. The fundamental question here links to the voluntary disclosure program and the voluntary disclosure agreement. And the key question: is SARS required to consider a request for remission of interest in terms of Section 39(7)(a) of the VAT Act after a VDP agreement has been concluded? And maybe even before I get into the aspects of the Tax Administration Act, let me just remind you of Section 39(7)(a) of the VAT Act, and that is the provision that talks about when interest. So if interest has been charged on an outstanding payment of VAT, all right, when might that interest be waived? Now, it all gets a little confusing with these interest provisions because there were amendments that should have been promulgated, but they haven't been, or they haven't come into effect yet. But in essence, if we look at this Section 39(7)(a), it tells us that the commissioner, so we're talking specifically around VAT interest, okay, interest on a late payment of VAT. So the commissioner, it says here, where the commissioner is satisfied that the failure on the part of the person concerned, etc., which has triggered this interest liability, if that is due to circumstances beyond the control of that person, and or it was not due to an intent not to make payment, etc. But this aspect of circumstances beyond the control of the vendor, the person who is owing the VAT, in that case, the commissioner has a discretion to waive the interest. All right, but now the issue here is that the taxpayer, Medtronic, had gone through this whole VDP process and they had reached a VDP agreement with SARS. Now, I'm sure you're aware that once a VDP agreement has been signed, that then becomes binding between SARS and the taxpayer. But before we get to that agreement, it's important to note, what does the voluntary disclosure program actually do for you? All right, so Section 229 of the Tax Administration Act lists the aspects of relief under the voluntary disclosure program. And so if you are able to negotiate a voluntary disclosure agreement with SARS, what it means is that there must have been a default, all right? And a default is defined in Section 225 of the Tax Administration Act, and it means the submission of inaccurate or incomplete information to SARS, or the failure to submit information, or the adoption of a tax position, which obviously was not correct, where the submission, non-submission, or adoption resulted in an understatement. Now, in this particular case with Medtronic, they had been the victim of a huge fraud committed by their accountant at the time. And this fraud, I mean, it must be one of the biggest frauds in corporate history, went on for years and years. But part of the fraud that was perpetrated involved under-declaring VAT liability to SARS, so under-declaring output VAT to SARS. And so when the fraud was discovered, obviously, the company then realized they had underdeclared VAT to SARS because the accountant had, with all her conniving, she'd understated the VAT. They then went to SARS and applied for the voluntary disclosure agreement. So it would seem it would be a classic case of where you would use the VDP. And yes, the VDP was used successfully. But the question here came to the interest. So the voluntary disclosure program gives you relief, like in this situation where the taxpayer has underdeclared their VAT liability to SARS. Remember, VAT is a self-assessment system, okay? Now, going through the VDP process, it means that there's no criminal prosecution, all right? So SARS would not pursue criminal prosecution for any statutory offense. There would be a relief for any understatement penalty, which is very important. And there would be relief for administrative non-compliance penalties other than penalties charged for the late submission of a return, which at the moment only links to your income tax returns anyway. But here, the 100% relief for the administrative non-compliance penalty would be the late payment penalty as far as VAT was concerned. So certainly the voluntary disclosure program, as it is set out in the Tax Administration Act, it gives relief for criminal prosecution, understatement penalty, and administrative non-compliance penalties, i.e. the late payment penalty. But there's no provision for interest. So there's no reference to a relief for interest as far as the voluntary disclosure program is concerned. Now, interestingly, the first version of the VDP program, which was actually promulgated, it came through, it was an act, it was the Taxation Laws Act of 2010, all right? That contained a voluntary disclosure program and actually did provide for a remission of interest. And they basically said that you could get up to 100% of the interest if you made your VDP application before becoming aware of an audit, or 50% if after. So there was provision for the interest to be waived, but that was in the first version, and that was scrapped when the final version came through, which is the one that is contained in the Tax Administration Act. Remember, 2010 predates the Tax Administration Act. Our Tax Administration Act is the Act 28 of 2011. Okay, so yeah, so there used to be a remission for interest, but that was scrapped. So now there's no reference to any remission of interest. But what happened here is that Medtronic went through the whole VDP process, signed a VDP agreement, which did give the relief for the criminal prosecution, the understatement penalty, the late payment penalty, but it made no reference to interest. And there was a massive amount of interest that was owing, because some of the understatement of that went back several years. And at the time, I understand that SARS had indicated to the taxpayer, let's just get this VDP agreement sorted out. We cannot refer to interest in here because the legislation doesn't allow for it. We can deal with interest separately. And that's why this taxpayer then went to SARS after signing the agreement and said, okay, fine, now can we have a look at this application for remittance of interest in terms of Section 39(7)(a) of the VAT Act. And then SARS said, no can do, because we've already signed the VDP agreement. All right. Now, just before I get onto the Constitutional Court judgment and what the Constitutional Court judgment has to say, when this matter went to the SCA, obviously the SCA found in favor of the taxpayer. We can see that by the fact that SARS has now taken this matter on appeal to the Constitutional Court. So the SCA appeal raised two issues. The first was whether the Tax Administration Act prohibited the remission of interest after a VDP agreement had been signed. And the second was whether SARS had a statutory duty to consider the taxpayer's request for remission of interest. And there was a split decision in the SCA, but the majority decision was that SARS' refusal to consider Medtronic's application of the interest remission, or application for the interest remission, was in violation of the Constitution. And SARS had a constitutional obligation to at least consider the application. So that's what the SCA said. The SCA did not say that SARS had to remit the interest. They simply said SARS does have a constitutional obligation to at least process and consider the application for the remission of interest. That's what came through from the SCA. Now, the SCA minority judgment said that there was no obligation because there's no possibility of remitting the interest. And this is, SARS then took this matter on appeal to the Constitutional Court. Now, without spending undue time on this, because we do have quite a few cases to get through, as interesting and significant as this case is, if we jump into the Constitutional Court judgment, what they say in paragraph 47, there's a glaring absurdity if you're going to permit a taxpayer to conclude a voluntary disclosure agreement, which makes provision for interest, and then at the same time allows the taxpayer subsequently to deal with issues, makes no provision for interest, and then allows the taxpayer to subsequently deal with matters relevant to interest. Okay, because the VDA cannot deal with interest. Legally, it's not addressed as part of the VDP process. But what they're saying is it would be absurd to sign an agreement and then say, okay, now you can go behind the scenes and apply for an interest remission. They said that would destabilize the VDP framework, and the finality of all voluntary disclosure agreements would be up in the air. So they did refer to the Endomeni case, which is one that comes up time and time again, looking at the interpretation. And they said an interpretation must not be given that leads to impractical, unbusinesslike, or oppressive consequences that will stultify the broader operation of the legislation under consideration. And they said Medtronic's interpretation is at variance with the salutary principle and must fail. And therefore, the appeal, SAR's appeal, was upheld with costs, including the costs of 2 counsel. The order of the SCA was set aside and replaced with the order that the appeal was upheld, and basically with costs. All right. So it wasn't a good day for Medtronic, and it really ends the matter. It means that whatever interest was payable is payable, and there's no other way of getting that interest remitted. So in essence, what this is saying is that once you've signed a voluntary disclosure agreement, what is in that agreement is the end of the matter as far as that particular tax issue is concerned. You can't dig back into the matter and deal with any other aspect, even though interest is not specifically addressed as part of the voluntary disclosure process. So the issue is that if you've got a lot of interest on the table, then you would need to deal with the interest and getting the remission of the interest first before you sign that voluntary disclosure agreement. Because what they're saying here is that once you've signed that voluntary disclosure agreement, that becomes the memorial and you cannot change it. All right. So yeah, quite an interesting principle that comes through there, and also just shedding a bit of light on some of the application around the voluntary disclosure process. Okay, then the other Constitutional Court decision, and this was this very interesting one, United Manganese of Kalahari, obviously a mining company up in the Northern Cape, and 4 other cases. And the 4 other cases, I've listed them here. There's the United Manganese, obviously, and then you've got Rapper, Forge Packaging, Absa Bank, and Louisville Metals. Now, these cases arose at different times and basically dealt with different matters. They dealt with different applications, although they had one thing in common, and that is that they all involved Section 105 of the Tax Administration Act. Now, Section 105 sits within Chapter 9, which is, of course, part of the dispute resolution process. And it basically, if you had to look at it one way, it kind of provides a shortcut. Instead of going through the whole process of the tax court where you have a dispute, it would enable a taxpayer to go to the High Court and ask for a High Court review or declaratory order. So basically finding a friend who's going to provide some kind of order that would then shortcut this whole process of going through the tax court. And we saw in the Absa case, they spoke about the protracted and convoluted process of going through the tax court. So it's understandable that, even when you look at some of these judgments today, and you can see how long it can take from the time that you first assessed until the time that your matter actually gets to the tax court. Can take a decade sometimes. But of course, it can also take a long time to go through the other courts, whether it be the High Court, SCA, etc., etc. But the idea with the Section 105 review is that it is an alternative method of dealing with a dispute. But, and this is what the courts were looking at here, when is it appropriate to use Section 105? Because we can't have every tax dispute running to the High Court. And basically, Section 105 involves a High Court discretion. All right. Now, all 5 of these cases, the taxpayers sought either a review or declaratory relief or both. So when you're talking about a Section 105 review application, it's the taxpayer going to the High Court, and there's 2 main avenues for a taxpayer to approach the High Court in a tax matter. It can be a review, and that can be either an administrative review under PAJA, the Promotion of Administrative Justice Act, or a legality review. Okay, so you can see the review can be a review of an administrative process where you haven't been fairly dealt with by SARS and in the course of carrying out their administrative function, or a legality review where there's something legally wrong about how something has been assessed or how something has happened. All right. So the review can be either administrative or a legality review. On the other hand, you could go to the High Court and apply for a declarator, and that involves an interpretation around a pure matter of law. So we talk about a review or a declaratory relief. Those are the two alternatives. Review has the two subsets, administrative and legality review. But those are the things that the taxpayer could potentially go to the High Court to seek. All right. Now, in each of these cases, the taxpayers were looking for one or both of those things, either a review on administrative or legality grounds, or a declaratory order, or perhaps both. And the question in each case was whether the taxpayer was entitled to pursue that relief in the High Court, having regard to Section 105 of the Tax Administration Act. Now, let me just at this point say that Section 105, I can just read it to you. It's a pretty short section. It says this. It says a taxpayer may only dispute an assessment or decision as described in Section 104 of the Tax Administration Act. And that's where you're appealing against certain decisions of the commissioner. All right. But you can only dispute in proceedings under this chapter, in other words, following the normal dispute resolution process, unless a High Court otherwise directs. So the first thing is that you would have to get a directive, a direction, all right, well, in most cases, from the High Court for them to intervene in that particular dispute, all right? So in this particular case, as I say, just going back to my previous slide, these taxpayers were all seeking either a review of a SARS administrative action or a legality issue around the raising of an additional assessment or some process within that, or declaratory relief, or both. All right. And could they go to the High Court? Now, of course, the question of whether they could go to the High Court in the meantime has gone to the SCA and then on to the Constitutional Court. And all 5 of these cases were heard in August 2024. And yet, if you have a look at this, the judgment was only handed down on the 31st of March 2025. So it took 7 months for this judgment to be handed down. Obviously, there was a lot of, well, it involved five cases. Well, that's one thing. And they were fairly different. But obviously a lot of discussion and analysis of interpretation, etc., to establish certain principles. And I'm not going to go into each of these cases in detail, but what I do want to just pull out of this, what I think might be useful in terms of overseeing the resolution of a dispute with SARS, is to say, when is it appropriate to use Section 105 and how would you use it, all right? When would you be likely to succeed taking your matter to the High Court? So in analyzing this in the Constitutional Court, their argument was confined to these questions: whether the taxpayer was entitled to use Section 105, okay? And if so, what order should be made for the further adjudication of the relief, in particular, whether the matter should be adjudicated on its merits by this court or remitted for hearing by the High Court. So, yeah, should we adjudicate this matter in the Constitutional Court, or do we send it back to the High Court or the SCA? All right, so coming out of this, if we look at Section 105, and I've just read that to you now, all right, basically there's 2 ways that a taxpayer could dispute an assessment in the High Court. And that's the review application. You're asking the High Court to review an assessment and set it aside, or you're looking for a declaratory or a declarator. You're applying for a declaratory order, and that would be on the correctness of an assessment. All right. So that's essentially what the taxpayer might be going to the High Court to apply for. Now, in these 5 cases, these questions were raised, and this I've taken from the Constitutional Court judgment because, yeah, it just sort of consolidates our thinking on these cases. So first of all, do you have to actually get a Section 105 direction? Now, if you look at the wording of Section 105, it says a taxpayer may only dispute in terms of Chapter 9 unless a High Court otherwise directs. And we saw that coming out in some of the SCA decisions where they were saying, well, you didn't first get the direction, you didn't first apply for a direction, therefore you can't proceed with this matter. And so the Constitutional Court was saying, do you in fact need this direction? You'll see later on they come out with an emphatic yes, generally you do, all right? Is that direction needed when a taxpayer applies to the High Court for a declaratory order on a question which, if answered in favor, would show an appealable assessment or decision is wrong? We'll come to that just now. What is the effect of the High Court's jurisdiction? And this is key. What is the High Court's jurisdiction? Do they have jurisdiction to consider this application from the taxpayer? In some of the cases previously, we saw that the outcome was no, the High Court does not have jurisdiction. Why doesn't it have jurisdiction? Many times because the taxpayer had not first applied for the direction, or it wasn't something that fell within the purview of Section 105. And then when and how should the direction be sought and adjudicated? And then what test should the High Court apply when deciding whether to give that direction? Is it exceptional circumstances? And if you have a look at these cases and the history of these cases, first of all, if you look at Section 105, again, just going back to this slide over here, it doesn't say that the High Court can only allow a Section 105 application where there are exceptional circumstances, okay? But this question of exceptional circumstances crept in the judgments that came through the High Court and the SCA, to the extent that actually it was almost accepted that if you're going to apply for a High Court direction, there has to be exceptional circumstances. But that was actually reading something into the legislation that wasn't actually there. And so in the Constitutional Court judgment, they're raising this point, all right? Does there have to be exceptional circumstances in order to apply the Section 105? If not exceptional circumstances, then what factors will the High Court take into account in deciding whether they are going to give this direction? In other words, if they're going to allow you to take this matter to the High Court, because you first have to get the direction, giving the permission to take the matter to the High Court. What factors will they look at in deciding whether to give you that permission? Then you would actually take your matter to the High Court, and they would then decide on your application for a directive, whatever the case might be. All right. What effect, if any, should Section 105 have where a review or declaratory application is brought? All right, so what can the High Court actually do? And this is especially before an assessment is issued. We're going to see a case later on, the Esparza case, exactly involving this, where they anticipated that SARS was going to assess them in a certain way, and so they applied for a declaratory order to clarify the interpretation of a certain term before the assessments were actually raised. Now, this says, what effect would Section 105 have if you are actually in that situation? All right, and well, it's interesting to see the two together, that in fact, yes, if you're applying for a declaratory application, you want the High Court to declare the interpretation of a certain matter before an assessment is issued. So, you know, what would the effect be of that kind of declarator? And then what is the nature of the High Court's power to grant or withhold a Section 105? In particular, does it involve the exercise of a true discretion, in which case the grounds of appellate interference would be more limited than otherwise? Okay, so this gets into a lot of legal stuff, and I don't want to get too bogged down in the real detailed legalities of all of this, but there are some important principles that come out of all of this. Now, of course, I said initially that if we start at the beginning, do you need a direction? Generally, yes, you need to get the direction to apply to the High Court. And so the judgment confirms that the direction is necessary to pursue a review or declaratory application in the High Court. They note that the High Court's jurisdiction to entertain a Section 105 application is conditionally suspended until that direction is granted. Okay, and that seeks to ensure that disputes will primarily be dealt with in the tax court, and that this is not an easy option, that there is a hurdle that has to be crossed if you want to take the matter to the High Court. This one, what is the effect, just to jump down over here, what is the effect of Section 105 on the High Court's jurisdiction? And this judgment clarifies that Section 105 conditionally suspends the jurisdiction pending the granting of the direction. And then when would this direction be given? And this really comes down to the crux of what everyone was waiting for with this. Do you have to have exceptional circumstances? And of course, the answer is no, it doesn't always have to be exceptional circumstances. This reference to exceptional circumstances crept in actually through the ABSA, I think it was unwittingly, through Sutherland's judgment in the ABSA case. So basically, the exceptional circumstances, let's pick it up at the second bullet point over here. It first found expression in the ABSA judgment in 2021, the High Court judgment. And there, Sutherland basically was looking at when this direction would be granted. And he said a court plainly has a discretion to approve a deviation from the normal dispute resolution route, okay? And that would be in what would be labeled exceptional circumstances. But he went on to say that it need not be exotic or rare or bizarre. It need simply be properly construed circumstances which sensibly justify an alternative route. And it basically, when there's a pure point of law, that would satisfy this question of exceptionality. Now, as I say, exceptionality is not actually written into the legislation here. This term, exceptional circumstances, we see it popping up in various places and in the Tax Administration Act, for example, in other contexts. But the reason why it's brought in here is because when there's a PARJA review, a review of a SARS administrative process, they would say, have you exhausted internal mechanisms? And you have to have exhausted those internal processes unless there were exceptional circumstances. And that's really where this test came in. But it then became much more generally applied, as I said earlier, that it actually became almost the norm to say, well, you have to have exceptional circumstances if you're going to use Section 105. But that was never the intention, that was never intended. And that was probably the golden message that came out of this overall Constitutional Court judgment, is that exceptional circumstances is not specifically required. All right, so they went on to say that test was adopted in these various cases because it came out of PARJA, and there you see the reference to Section 72C of PARJA, looking at exhausting internal remedies unless there are exceptional circumstances. But then in the Constitutional Court judgment, he specifically says he disagrees with the statement that an exceptional circumstances test is clear from the language, context, history, and purpose of Section 105. And without reading all of this, basically saying the key test in Section 105 is not exceptional circumstances. All right, it says Section 105 is workable and effect can be given to it without adopting a heightened exceptional circumstances test. So then what is the test that one would use to decide whether Section 105 can appropriately be used? And he said, going through all of this, he said in summary, the test for granting a Section 105 directive is not whether there's exceptional circumstances, but whether there's adequate justification for departing from the default remedy, which is your normal tax dispute resolution process. And he said such justification could fairly be tested by asking whether the departure is appropriate. Is there good cause for the departure? All right, so if you're able to justify that there's good cause for making use of Section 105, that would be adequate. You don't have to show exceptional circumstances in all cases, unless you are specifically bringing a PARJA review and you have not exhausted all the internal remedies, then you'd have to show that there are exceptional circumstances, because that is required in terms of Section 72C of the PARJA, the Promotion of Administrative Justice Act. All right. But otherwise, the Section 105 review doesn't specify the factors, but the court then did go on and they did give the following general guidance on factors that might be relevant. So these are the things that one could say, all right, this would justify making use of a Section 105 review. It would generally be inappropriate to grant direction if the taxpayer has not first objected to the assessment. And that's assuming that there has been an assessment. So you can't just say, oh, here's an assessment, I'm unhappy with it, I'm going to go to the High Court and ask them to review this assessment. They're saying it's generally appropriate that the taxpayer generally, all right, the taxpayer should first have objected to the assessment. Sorry, I've lost my place there now. Yeah, there we go. And SARS has not yet given. So there should have been an objection, and SARS should have given a decision on the objection. That would be the acceptable norm. All right. A factor mitigating against a Section 105 direction is when the taxpayer is pursuing other grounds through an appeal to the tax court because they don't want piecemeal adjudication. All right. So that would mitigate against the court giving remember the permission given by the court, the Section 105 direction, that would mitigate against it. The closer a review ground is to a permissible ground of appeal in the tax court, the less likely that granting a 105 would be appropriate, right? Because again, they would prefer to see this matter going through the tax court, but only when there are factors that would justify a departure from that rule would the High Court approve a review through the High Court. The High Court must consider whether there are advantages favoring High Court adjudication over the tax court adjudication, such as establishing precedential value or guiding future assessments. And a Section 105 direction may be suitable in cases involving egregious and willful procedural irregularities. All right, so where SARS, for example, has submitted an invalid Rule 31 statement, or they've changed the grounds of their appeal so substantially. We've seen that coming out in recent cases, and then the taxpayer takes that matter on review. So, where there's egregious and willful procedural irregularities on SARS' part, that is inappropriate or unacceptable administrative action, and that is the kind of review that can be taken before the High Court. All right. For example, in the ABSA case, and we'll come to this just now, SARS did an audit, and then they decided that it looked like there was massive tax avoidance going on, and that they were going to raise an additional assessment. So they issued the Section 80J notice notifying the taxpayer of this outcome. Now, what should happen is the taxpayer should be given the opportunity to rebut that decision of SARS, all right? But before the taxpayer had an opportunity to do that, in the ABSA case, SARS went ahead and raised this additional assessment on the basis that the GAR provision did apply. So that was an example of an egregious and willful procedural irregularity. It should not have happened like that. SARS can't just go ahead and raise the additional assessment without giving the taxpayer the opportunity to rebut SARS allegations in the audit findings. All right, so that was an example in the ABSA case. Now, if we just take this and we apply it now, we go, and I'm just going to very quickly touch on the outcome of each of these 5 cases. Now, the United Manganese case, that was an application for review where SARS had been non-compliant with Section 42.2, probably just only one 2 in brackets there, but anyway, Section 42.2b of the Tax Administration Act, and that deals with the audit. All right, so Section 42.2b says that SARS must issue within 21 business days. Basically, they must provide the taxpayer with a document containing the outcome of the audit, etc. So here is a situation where there has been procedural misdirection by SARS, similar to what we saw here, egregious and willful procedural irregularities. All right. And in this particular case, the taxpayer was going to the High Court to say, hold on, have a look at this. The SARS has been non-compliant with this particular provision of the Tax Administration Act, and they wanted a declarator, all right, an interpretation. This was the other matter of a particular aspect of the definition. So they wanted the High Court to come with an interpretation. So that was a declarator, and they wanted a review of SARS administrative action. Now, the finding here was that neither the review relief nor the declarator was appropriate for the High Court adjudication. Therefore, a Section 105 direction could not be granted. So the court, they did give leave to appeal to consider this application from United Manganese, but at the end of the day, they said in this particular case, and coming to the facts of the case, it wasn't appropriate, and so they said no, the High Court cannot entertain that application. So strike 1 against the taxpayer there. In the case of Rapid Resources, and here it was an application for a review of merits and procedural non-compliance, And here, the Constitutional Court said that until a Section 105 direction is granted, so you have to apply for the direction first, and until you get that direction, the High Court's jurisdiction is conditionally suspended. They can do nothing until you get the direction. Then you could take the matter to the High Court. But in this particular case, they did not apply for the direction. And so they hadn't crossed the threshold as far as that was concerned. So they dismissed the appeal over there. But RAPA may refer the matter to the High Court. They could go back to the High Court. In the forged packaging case, and this was an application for review of SARS non-compliance, again with the Section 42(2)(b). I don't know why I've again put 2 2s in there, but anyway, with the audit outcome letter and Rule 31, which is SARS on the appeal. That is their statement of what their side of the story is, all right, and what their arguments are. And so in this particular case, the court refused to condone the taxpayer's late filing of the application for leave of appeal. So this was the key thing here with Forge, is that they were late in filing their application for leave to appeal. They had gone beyond, there's a period of 183 days under the rules, and they had gone beyond that date, and they had not got condonation of the late submission. And based on this, and also because they didn't have a reasonable prospect of success, the court dismissed their application and said there's no basis to interfere with the High Court's decision. So far, not going too well. 3 out of 3, having gone all the way through to the Constitutional Court and finding against the taxpayers, all right? Fortunately, a little glimmer of hope on the horizon with the ABSA case. And remember, I said earlier that was where SARS wanted to apply the general anti-avoidance provisions, where they wanted to assess ABSA on the basis of looking through transactions, not on the basis of what the contracts were actually demonstrating, saying that there was tax avoidance and there was an impermissible avoidance arrangement, and therefore they wanted to assess ABSA on that basis. But in this particular case, the court actually found in favor. All right, so this was ABSA taking the matter on appeal from the SCA, and the court granted the taxpayers leave to appeal. They found that the 2 issues raised by the taxpayers were indeed pure points of law. And the issues were whether ABSA had been a party to this arrangement. Because actually what ABSA had done is they'd entered into certain investments. They had, but within the entities that they had invested in, those entities had entered into various contracts and various arrangements, which SARS said was an impermissible avoidance arrangement. But ABSA is saying, we just invested into this. We didn't know what went on behind the scenes. And so that was the issue around the point of law. Were they actually a party to that arrangement? Okay. So in this particular case, they said, well, these are pure points of law. They can be considered by the High Court because they're looking at an interpretation matter. Although the presence of other disputes about the assessments mitigated against the High Court adjudication, it allowed the High Court's direction to stand. The court granted leave to appeal the decision of the SCA and held that the remaining issues in the appeal would stand over, etc. So at least ABSA was successful. They'll have to go back to the Constitutional Court or back to the court in terms of getting this interpretation around whether they were actually a party to this impermissible avoidance arrangement. And then the Louis-Van Metals case, which involved a VAT aspect and looking at the interpretation of this particular provision, Section 11(1)(f), a zero rating provision around gold bars. So they were looking for a declarator to interpret that provision in a certain way. The court said here that because no assessment had been issued when they applied for the declarator, a Section 105 direction was not required. So they didn't have to get the direction first because no assessment had been issued. All right. And the SCA had erred in declining to decide the merits of the case. Therefore, the court granted leave to appeal the order of the SCA and held that the remaining issues would stand over, etc. So, yeah, so where the assessment has not yet been issued, where you're looking for a declarator, an interpretation matter, that doesn't require a direction. You can just go to the High Court and apply for the declarator. That's what was coming through in the Louis-Van case. So they had an element of success as well. Although who knows what the actual interpretation would be, that is a matter to be decided on another day. So out of the 5 cases that came to the Constitutional Court, only 2 were successful for the taxpayers and the other 3 were unsuccessful. So not a great day in court for all of the taxpayers involved, and certainly a lot of cost involved in terms of legal fees, I'm quite sure. But I think, and before I close that off, it is a very, very important judgment. I know Section 105 is not something that you're going to come across every day, but it is an important aspect of the dispute resolution process. And so it is quite important to at least know when it would be appropriate to make use of Section 105, what would the prerequisites be, what is the likelihood of success if you're going for a Section 105 application. And yeah, is it a review application? Is it a declarator? What exactly are you looking for here? So this is where this judgment was very, very important, and certainly has set a benchmark and has handed down a lot of very important principles around interpretation, around the jurisdiction of the High Court, and so on. Okay, so a very interesting case there. Then we come down to the SCA, and over here we look at the Sishen Iron Ore Company. Now, Sishen Iron Ore being a mining company, and you might say, well, why are we looking at a mining case, but it has other aspects that are actually really interesting, and yeah, it's certainly worth having a look at, especially around some aspects of what happened in this case, and then also looking at the question of legal costs, right? Because this dealt with, amongst other things, the deduction of legal costs. So in this particular case, yes, it was a mining company, and what had happened operating in Sishen up in the Northern Cape. And when you look at a setup with mining, they wanted to expand their mining operation, but they had to have a safe zone around the mining operation. That safe zone apparently is quite a small zone. It's not large, but it's an area where people cannot be living. And surprisingly, I think it's only about 500 meters. All right. So there's this band, this kind of safe band around the actual mining operation. So as they were looking at expanding their mining operations, they had to actually relocate this neighboring residential township. All right. So literally move all of these houses. All right. Well, I mean, I'm sure they didn't literally lift up each house and move it, but they had to relocate the townships and move the people out of there, move them further away so that they were not within this buffer zone. They also had to relocate infrastructure within the mining area, and they also had to relocate a massive power line, a 66 kV power line, which supplied electricity to the mining equipment. So huge costs incurred in these relocations. But now what is also interesting is that they incurred legal costs regarding the relocation of the township. So what they actually did is they recruited a legal team who went in and worked with the community and actually spoke to and interacted with the people in the community. And why did they do that? It was to avoid any later legal action that might arise. So it was actually to avoid legal claims that might otherwise arise if they just left people to their own devices. And then, there's a lot of people don't like change at the best of times. And when you're being relocated, you can imagine it can result in quite a lot of possible grievance, possibility for later legal claims, and so on. And so they incurred these legal costs with regard to relocating the township. And the question was whether those were deductible under either 11A, general deduction formula, or 11C, which is our special deduction for legal fees. So if we have a look at these, expenditure in relocating a residential township, pretty much capital expenditure, right? But then they were looking at these special deductions that apply, where you can have capital expenditure that qualifies for deduction when it relates specifically to mining. Okay, and that's where Section 3611 and 367C come in. And also with the relocation of the power line, there you see 3611 again. But even here, alternatively, under section 11A, the general deduction formula. Now, with all of this, to consider whether these amounts were allowed as deductions, the taxpayer claimed them as deductions. SARS said no, they're not deductible. And of course, it came back to this issue around burden of proof. All right, so the burden is on the taxpayer. The onus of proof is on the taxpayer to prove that an amount is either not taxable or deductible or allowed to be set off in some way, like setting off an assessed loss, setting off rebates, etc. Okay, so the onus is on the taxpayer. So has the taxpayer discharged that burden of proof? And then the other aspect that came through here was Section 89 pot interest. All right, because, you know, SARS raised the additional assessment on the taxpayer. And so on that basis, there was underpayment of provisional tax, etc. And that resulted in your 89 quat interest. Now, the 89 quat interest, there is grounds for waiver if the interest arose because of circumstances beyond the control of the taxpayer. And the question then is, should SARS have waived this interest? Was this interest due to circumstances beyond the control of the taxpayer? All right, so if we have a look at it, the finding of the court was that the relocation expenditure of the township was deductible under 3611E, and that links to the mining right, etc. It was essential for the continuation of the mining operations. The SCA had reasoned that unless the infrastructure was relocated and the Dingleton residents, that's the name of the township, Dingleton, unless they were translocated, the progression of the mine pit to the west, as contemplated, could not continue. So it was essential for the mining operations that they had to do this. And now if you look at section 3611E of the Income Tax Act, which is, you know, unless you're involved in mining, you're not really going to look at that, but it talks about expenditure incurred in respect of a mining right. So is it specifically closely connected to the mining right? And they came to the conclusion that it was. The moving of the power line similarly allowed because it was integral to the operation of the mine equipment and essential for the income production. So those were definitely the bigger amounts as far as the materiality was concerned. And so the conclusion was, yes, they were allowed. But now we come back to the legal expenses. And my own view here is I do wonder if perhaps the SCA was feeling like, well, SARS was losing out quite a lot on the deduction of these expenses around the relocation, and maybe, you know, let's be nice to them as far as the legal expenses were concerned, because the conclusion was that the legal expenses were not deductible. And the reason there is they said, because if you're looking at legal expenses relating to the trade of the taxpayer incurred in the production of income, and they said, well, the taxpayer's trade is to mine iron ore, not provide legal assistance. Now, I don't know, to my mind, I'm not convinced about that argument, but that was the outcome of the SCA. So they said the legal expenses were not deductible. But what they did say is that the 89 quat interest should be waived. Now, if we just have a look at that in a little more detail around the legal expenses, okay? So the legal expenses, as I said earlier, comprised fees paid by the taxpayer to legal practitioners advising the residents around the relocation to avoid future legal claims and disputes. All right. SARS maintained that the legal expenditure was not incurred in the production of income, as it was not sufficiently closely connected to the business operations of Session for it to be proper, natural, and reasonable to regard it as part of their operations. All right, so not closely enough connected to the operations of the taxpayer. Just give me a second. Sorry, part of the joys of doing the webinar at home, I have a dog that suddenly needed to go out. All right, so not closely enough connected to the operations of the taxpayer. Now, if we look at 11A, of course, you're all aware of the general deduction formula. But if we look at section 11C, would the legal costs be allowed under section 11C, perhaps? And the purpose of section 11C is exactly that, when it is difficult to show that your legal costs are closely related to the production of income for the purposes of trade. 11C then steps in and says, well, any legal expenses, and then it specifies certain types of expenses, which covers the kind of legal fees you're talking about here, actually incurred in respect of any claim, dispute, or action at law. All right. Now, and I've made the point here a couple of times that these legal expenses were incurred to avoid any, so they were in respect of a claim, dispute, or action at law. They revolved around that, but the taxpayer in this case was preempting that from happening. Now, the tax court had disallowed the legal costs as deductions because they said that as the removal and relocation costs were deductible under those provisions, the legal costs were not incurred in terms of an existing mining right. So they said, okay, I can't deduct it. It's not related to a mining right. But then they also said that it is not allowed as a deduction under Section 11C. And yeah, as I said earlier, I'm not sure I 100% agree with that. If you look at the reason why the taxpayer was incurring these legal costs, but it seems, well, the taxpayer won this case in terms of the materiality aspect with the relocation costs, but certainly it's a bit strange around the legal costs. Okay, so they make the point that trade was mining, not to provide legal assistance, but surely that's all part and parcel of your business. Taking legal advice relating to your employees, making sure that everything is done above board, etc. That must surely be part and parcel of your business. But that what they said, and this comes back to Section 102, is that the taxpayer did not discharge the burden of proving that the legal expenditure was incurred in the production of its income. They didn't establish that close connection between the legal expenses, the legal work that was being done, and the actual operations of the taxpayer. All right, so they disallowed the legal expenses. But if we have a look at Section 89 quat, I've just seen that the Reserve Bank has cut the repo rate by 25 basis points. So that's an interesting one. Yeah. Okay, just a bit of an aside. All right. And then they said in reconsidering the aspect of the interest, looking at 89 quat, remember I said that the provision is that the interest can be waived if it has arisen because of circumstances beyond the control of the taxpayer. And when you look at the factors relevant to the exercise of this discretion, the SCA said this can include where a taxpayer believed there were grounds which excused liability from the payment of tax on which interest sought to be raised, that the test whether the grounds are reasonable is objective, etc. Now, it does make the point here, reliance by the taxpayer on expert advice, even if this is wrong, will in most cases constitute reasonable grounds for the action taken. And we've seen this coming through time and time again in many tax cases where taxpayers are successful in getting their 89 quat interest waived on the basis that they relied on expert advice. They completed their provisional returns, their tax returns, etc., based on their reliance on that expert advice. And the fact that SARS then took a different view and the interpretation took a different turn meant that that was actually a circumstance beyond the control of the taxpayer. So interesting that that was what was coming through here. Session had acted on the advice of, in this case, KPMG, which confirmed their position was more than likely not to be upheld before a court. And so in this particular case, they said that the 89 quat interest should be waived. All right. So quite an interesting one to come to conclusion that the interest was beyond the control of the taxpayer. Okay, let me just quickly have a look and see if anyone has a question. I see there is something in the Q&A. Yusuf is asking, if the legal expenses were paid to mitigate future expenditure, would this not be deductible? Okay, no, we can't read that wording into the provision. To mitigate future expenditure, that is not a qualification for deduction. All right, so what you have to show is that it's expenditure incurred in the production of income in the course of carrying on a trade. So there's got to be that close connection between the legal work that's been done and the actual operations of the taxpayer. And if you can't meet that requirement, Then you've got to go to 11C, and then it says that it must be in respect of a claim, dispute, or action at law, and that could be a future claim, dispute, or action at law. All right. And it does say arising in the course of or by reason of the ordinary operations of the taxpayer. Okay, so yeah, but to mitigate future expenditure itself is not the criteria there. Okay. All right. Let's see if there's anything else. No other questions coming through just yet. Okay, well, let's carry on and have a look at Aven mining shafts and underground versus SARS. All right, another mining company. But here we switch tack, and now we're looking at VAT. And just a very interesting point that comes through this case, and you'll see that this judgment was handed down by the SCA on the 17th of March 25. I have given you live links to these judgments, so you can click through to them if you want to. Now, in this particular case, the vendor carried on the business of sinking shafts and doing mining construction activities, and they were looking at an input tax deduction. So if we look at the rules around claiming input tax, of course, in terms of the VAT Act, and you've got to look at the definition of the input tax, section 16, etc. But where VAT has been paid on the acquisition of goods or services, to the extent that those goods or services are going to be used for making taxable supplies, you would be able to claim your input tax. However, having said that, there are certain provisions, certain prohibitions where you are simply denied the input tax, and that comes through in section 17. So section 17 has got the apportionment rules, all right? So if you're making both taxable and exempt supplies and you've got overhead costs, you would have to apportion and only claim the input tax to the extent to which it is used in making taxable supplies, all right? So that's the one side of it. But then, of course, you've got the other, not just the apportionment rules, but you've got the specific prohibition rules. Okay, so those specific prohibition rules in section 17.2, all right? Section 17.2, it talks about, in the first instance, goods or services acquired for the purposes of entertainment, all right? And then it goes in B, it talks about fees and subscriptions, all right, of a sporting, social, or recreational nature. C talks about your motor car, all right? You can't claim input tax on a motor car. D talks about your superannuation schemes. So there's basically these four instances where you have a specific prohibition on claiming input tax. And it seems that the reason for these prohibitions was just to avoid abuse. When the VAT legislation was first brought in 1991, you know, they tried to keep that as broad and standard-based as possible without too many ins and outs and different rates and so on. But they did say that as a bit of an anti-avoidance mechanism to prevent abuse, they would have these prohibitions. Now, this prohibition here on entertainment, okay, so the question here was whether the input tax that had been paid for accommodation and food. So the vendor, Avenge, paid for accommodation and food for that was then provided to its employees. And the question was, could they claim the input tax on that? And they were specifically looking at this reference to section 17.2A1BB. All right, now, what that basically says is that 17.2A, as I said before, tells us that you can't claim input tax on entertainment. However, it then goes on to say, except in certain circumstances. And then this little bit here, this subparagraph BB of this proviso, which says except in certain circumstances, it says except where the vendor supplies entertainment to an employee, all right, to the extent that the taxable supplies of entertainment are made for a charge which covers all direct and indirect costs of the entertainment. Now, the other possibility here would be the AA, which is talking about where you're carrying on the business of entertainment. That would be if you're running like a spur, for argument's sake. Clearly, you are buying food to sell food, but you're in the business of supplying entertainment. You're charging a fee or a rate that covers your costs. Then you'd be able to claim the input tax on this aspect of entertainment. Because important is to note that when we look at this definition of entertainment, in Section 1 of the VAT Act. So we're saying you can't claim any input tax on costs incurred for entertainment. And when you look at the definition of entertainment, it simply says, what is entertainment? It is the provision of any food, beverage, accommodation, entertainment, amusement, recreation, or hospitality of any kind by a vendor, whether directly or indirectly to anyone in connection with an enterprise. All right, so if you buy a microwave oven for staff to warm up their baked beans on toast for lunch, that's all related to entertainment, and you can't claim the input tax. If you buy a coffee machine so they can make their cappuccinos, you can't claim the input tax because that's expenditure incurred on entertainment. Except this proviso BB says, unless you are providing the entertainment to employees and you're charging you're imposing a charge which covers all direct and indirect costs of that entertainment. So if you buy a cappuccino machine and you install it and you tell your employees they must pay you 40 Rand per cup for the cappuccino, well, now you're charging something that covers the costs of but remember, it's direct and indirect costs. So, it depends whether that 40 Rand covers it. I'm guessing it does. Then you would be okay in claiming the input tax. Coming back to Avenge, now they're in the mining business. They're taking employees out onto site. They are paying hotel bills and they are paying food for this project, and they want to claim the input tax. And the taxpayer here was arguing that they do charge something that covers all of the direct and indirect costs because their contract price to the customer factors in all of these costs. And so they were saying they're providing this to the employee. They are imposing a charge that covers all direct and indirect costs. And therefore, they said they should be entitled to the input tax. So the question was whether they could, in fact, claim the input tax. So was the accommodation and food acquired for making taxable supplies? In the ordinary course, well, no, because they don't carry on an entertainment business. But then did they charge something that covered all direct and indirect costs? Because that's the BB part of that proviso. And basically, the taxpayer argued that, yes, they did charge, as I say, because they recovered that back in the contract price that they charged to their clients. And they also argued that VAT operates on a neutrality principle. So, SARS is not out of pocket, because whatever we claim back here, we are going to be on charging to where we have a value add situation. SARS, on the other hand, said no, the expenses fell squarely within the definition of entertainment, and there's no deduction allowed because it is specifically prohibited under Section 17(2)(a), unless one of those specific exceptions applied. And they said, well, you're not engaged in the business of supplying entertainment, so that proviso AA doesn't apply. So then you're coming back to BB, which is saying, are you charging something that covers all your direct and indirect costs related to the provision of that entertainment? And SARS said the vendor did not charge its employees for these costs, and it did not conclusively prove that all the direct and indirect expenses related to food and accommodation were recovered. So although the taxpayer said we have recovered the cost in our contract price that we're charging to the client, SARS said, well, you haven't conclusively proved that. All right. And they're coming back to this neutrality principle. They said they can't override explicit statutory prohibitions. The VAT Act's prohibition on input tax on entertainment was a legislative safeguard against potential tax abuse. And the court actually found in favor of SARS and against the taxpayer here, because at the end of the day, they basically said that the taxpayer has not conclusively shown that their charge covers all of the direct and indirect costs relating to the provision of this entertainment to the employees. So they talk about the preamble that qualifies the exceptions, paragraph AA and BB, which I've referred to now a couple of times. And it says that it must be in respect of goods or services acquired by the vendor for making taxable supplies of entertainment in the ordinary course of an enterprise. And they say entertainment is not the enterprise of Avenge. The input tax incurred was not in respect of goods or services acquired for the purposes of making taxable supplies. They were required in respect of making to make supplies of sinking shafts, etc. So that subparagraph AA did not apply. But if you look at subparagraph BB to say, did you impose a charge that covered your direct and indirect costs? They say, even assuming a taxable supply of entertainment is made for a charge in the course of the enterprise, Avenge failed to recover that charge from its employees directly. In the alternative, if it would be sufficient for the purpose of the exception to recover from the clients, it failed to establish that what it built into the price covered all the charges. So actually, at the end of the day, it also comes back to that section 102 aspect, all right? The onus of proof on the taxpayer. The taxpayer was unable to properly discharge that onus of proving that the contract price covered all the direct and indirect costs relating to the provision of this entertainment. It seems to me that they've lost this case on something that probably should be capable of being demonstrated. In other words, just pull out your costing sheet and show how your contract price actually covers all the direct and indirect costs of this entertainment, the accommodation and the food that it's providing to the employees. It shouldn't be such a difficult thing to prove, right? And yet that's why the taxpayer lost the case here, is that they were unable to basically show and demonstrate that there was a full recovery through the contract price. So that we could say the takeaway here is that the judgment underscores the deduction of income taxes only permitted when explicitly permitted by the legislation. So you've got to be careful about this. You know, I think sometimes people get a little bit lax in terms of maybe their controls around claiming input tax deductions. And some of these fundamentals that have been in the VAT Act ever since the VAT Act came in more than 30 years ago, basically 34 years ago now. But are you sure that you've got the controls in place to make sure that only valid input tax deductions are actually taken into account? And notice that input tax paid on employee-related entertainment expenses, food and accommodation, is not deductible unless one of those specific exceptions is met. And if you feel that you're entitled to one of those specific exceptions, then you have to be able to discharge the onus to prove the entitlement to the deduction. And it's these types of things that I was alluding to right at the beginning of the webinar when I was saying that SARS is going to be on the warpath with tax collections and picking things up like this on their audits. And so, you know, we have to understand what the legislation says, and we have to keep proper records, or we have to keep proper controls to make sure we're processing transactions correctly, that we are only claiming input tax when we are absolutely entitled to the input tax, and that we are charging the correct amount of output tax. And if you are claiming input tax deductions, that you have all the necessary documentation to protect yourself in the event of a SARS audit. Okay, so in this case, the taxpayer's appeal failed. And yeah, quite a nasty one. There was a lot of money involved in this case. It wasn't just a small amount of input tax. All right, so that's a sad saga of Avenge. And then just perhaps, yeah, let's have a look at this case, Henk. You probably remember this case from the High Court decision, and here it is in the SCA. So the taxpayer has taken this matter on appeal through to the SCA, and it's an important one because it does establish some very important principles in a business rescue situation. So this company was in business rescue. Sorry, before I get too far, let me just check whether there's any questions. No, I don't see any questions. Okay. All right. So this company was in a business rescue situation. And the short story is that there was a tax liability that arose. Sorry, I'm just battling to get my slide to go back to the previous one. There we go. Yeah, there we go. Okay. So there was a tax liability that arose because of an additional assessment that SARS had raised. So this additional assessment related to the 2017 year of assessment. The 2017 year had been assessed. The original assessment was raised before the business rescue procedure started. After the business rescue procedure started, SARS raised the additional assessment. All right, so we had this additional tax liability arising from this assessment relating to a year that ended before the business rescue process started. And remember, the original assessment was raised before the business rescue process started. So the question is whether this additional tax liability is a post-commencement debt or a pre-commencement debt. Because you need to, with business rescue, draw a line in the sand, basically, and say, right, which debts are there up to the date of my business rescue plan being put together? All right, then I'm going to say, what are my creditors? What debts do I owe at that point? Those are all my pre-commencement debts. And that would have included my original assessment in this case, except there was no tax debt on that. All right. But then any debts that arise post the commencement date, the commencement of the business rescue process, those debts have a different status and they are dealt with differently in terms of the business rescue process. So we have a very clear dividing line, and we had to establish here whether this additional tax liability falls on the pre or the post side of that line. Was it pre or post commencement of the business rescue process? And that leads us to this question, when exactly does a tax liability actually come into existence? So we saw this being raised in the Visa case a few months ago. That, of course, was related to a different aspect around a preservation order being taken and SARS taking collection steps around debt. But it was also a question around when does tax debt actually come into existence. And so there's two arguments here. The one argument says that a tax debt only comes into existence when an assessment is actually raised. And that's what SARS was arguing here. They were saying our additional assessment was only raised in 2018 or 2019, so that's a post-commencement debt. It only came about when the assessment was raised. The other argument is to say, no, a tax liability actually arises when the underlying transactions are entered into, and that can be for VAT as well. All right, the time of supply rules, when was the supply made? That triggers output tax. Income tax, you've got your gross income, all right? When does an amount accrue? And then when do you claim your deduction? So during the tax year, that is actually giving rise to tax liability. But the purpose, if we take that argument says the purpose of the assessment is to quantify that tax debt. All right, so it's to say the tax debt was there, but now we're quantifying it. The other argument is to say, no, there is no tax debt until the assessment is actually raised. All right, so which one is true? Because that's going to make a big difference. You see, what happened here is that Henk had this additional assessment, which gave rise to additional tax liability, but during the post-commencement phase, so while they were in business rescue, obviously they're still trading, things are still going on, they had a VAT refund that arose. And then SARS, remember earlier I said SARS is doing a lot of set off, all right? So what they wanted to do here is they wanted to set off. They said, we're not going to pay you your VAT refund. We're going to set that off against this additional assessment liability. That's what they wanted to do. And Henk was saying, no, you can't do that because you're mixing oil with water. The additional assessment is a pre-commencement debt. VAT is a post-commencement refund, and you can't mix the two. So that's the argument that the taxpayer was making. All right, so the background, they filed the 2017 return. They showed a loss, so there was no tax liability. They were assessed in November 2017. SARS said they're going to do an audit. Okay, fine. But then Henk went into business rescue in January 18. Okay, so February 18, they had the first meeting of creditors. So they are now in business rescue, in the business rescue process, okay? And then April of that year, SARS completed the audit and they realized that there's actually taxable income of 16.8 million rand, okay, not a loss of 46,000. They raised an additional assessment and that gave rise to tax liability with penalties and interest of 5.6 million. So this is the liability, 5.6 million, arose from this additional assessment, which had a due date for payment. Okay, in those days they had a first date, second date. The due date for payment was the 31st of May 2018. So SARS was arguing that this was a post-commencement debt because they raised the additional assessment after the business rescue process had commenced. All right, the business rescue plan was tabled in May, 31st of May, also adopted by creditors in June, etc. And at that point, so if you said what were the creditors at the commencement date of the business rescue, it included SARS creditors for VAT and PAYE of 3 million rand. That was certainly pre-commencement debt. That is not the subject of the inquiry here. But what happened post-commencement is we had this VAT refund of about 1 million rand. And so SARS wanted to set off the refund against this additional tax liability of 5.6. Okay, we accept that 3 million rand was a pre-commencement debt. That's another matter. But the VAT refund arose post-commencement. The question is, this 5.6 million is a pre-commencement or post-commencement? And basically looking at the legal framework, the Income Tax Act, Section 5, which establishes the general liability to pay income tax, the Tax Administration Act, looking at what is an assessment, the process of raising additional assessments and issuing these assessments, the Companies Act around the business rescue process. These were all the relevant legal provisions that had to be considered. So in terms of the business rescue process, of course, that is a legal process designed to facilitate the rehabilitation of a financially distressed entity, and it involves appointing a business rescue practitioner, placing a temporary moratorium on the rights of claimants. Okay, so that's that pre-commencement debt, temporary moratorium on the right to claim payment for those pre-commencement debt. In terms of Section 154 of the Companies Act, no creditor, including SARS, can enforce a debt that is the pre-commencement debt, except in terms of the business rescue plan. So it ring fences those debts, and it safeguards the company from claims for those pre-commencement debts. And it facilitates this business rescue process, facilitates the development of a business rescue plan. So the idea is to try and trade through this financial crisis, obviously, and try and rehabilitate this company. And that means you just put on ice the claims of the creditors to settle their debts. Pre-commencement, let's just put that over there. We'll deal with that later. But in the meantime, let's try and get this company to succeed. Okay, so that's the idea with the business rescue plan. So coming back to this 2017 liability, the High Court, all right, had said, relying on Esselman, that this assessment basically establishes the tax liability. So they were looking at the interpretation that had been applied by this case back in 1991. It was actually a Namibian Supreme Court of Appeal case. And they said that the issuing of an assessment is crucial. There's no debt until an assessment is issued. And that was then basically the finding of the High Court. But that's why Henk took this matter on appeal to the SCA. And here you see they're applying for declaratory relief, coming back to what I was saying about Section 105 earlier. So they're applying to the High Court for a declarator saying that this is a pre-commencement debt, not a post-commencement debt. In essence, that's what they were applying for. All right. And the SCA ruled that the High Court had jurisdiction, and a Section 105 direction was not required because there was not an assessment yet, linking to what I was saying earlier around Section 105. Okay. And the taxpayer wasn't challenging the correctness of an assessment. They were challenging this point of law, the interpretation of the law. How do we interpret when a tax debt comes into existence? All right. So the taxpayer was disputing the manner in which SARS characterized the income tax liability arising from the 2017 additional assessment, and disputing whether the liability could be set off against that 1 million rand VAT refund, which was clearly post-commencement. All right. So this additional 5.6 million rand tax liability, if it was a post-commencement, yes, you can set it off against the VAT refund. But if it's pre-commencement, no, you can't set it off. And so they were really looking at this declarator as to whether it was a pre or post-commencement debt. All right. And so looking at this question, when does the tax debt come into existence? Looking at Section 5, it talks about a liability for income tax in respect of the taxable income received or accrued during the relevant year. And immediately after the end of the year or shorter period, the tax debt is owed, even though it may not yet have been quantified and is not due and payable. But they're saying, when does the tax debt come into existence? during the year of assessment when the transactions actually take place. The role of the assessment is just to quantify that debt. And they said the process of quantification is by means of the submission of the return, and then SARS assesses the taxpayer based on what is in the return. And then, of course, yes, SARS could do an audit, and there might be an additional assessment that follows at the end of that process. But the essence of this is that the tax debt comes into existence during the tax year based on the transactions that are happening. And the notice of assessment just quantifies the debt and fixes the date by which the debt becomes due and payable. But the actual debt comes into existence through the transactions. That's what the SCA concluded. And then they said SARS is empowered to make the additional assessment where the original assessment does not reflect the correct application of the Tax Act, all right, which that's under Section 92 of the Tax Administration Act. They say the effect of this is to permit SARS to requantify and correctly state the debt, and the requantification does not create a new liability. It's just a requantification. And so in this case, where the original assessment was issued before the business rescue commencement date, the reassessment, the additional assessment that came through after the commencement date, was just a requantification of an existing debt. And therefore, the conclusion is that the debt was a pre-business rescue liability, and therefore it could not be set off against that refund, which was a clear post-commencement refund. So it does create, does give some certainty in the business rescue process. I mean, it's been both hailed and criticized in terms of this judgment. It does establish the principle that there's a difference between the time a tax debt is created, when it is quantified, and when it is due and payable. And so when we say, when does a tax debt come into existence, it's based on the transactions that give rise to that tax debt. But it might only be quantified and become due and payable sometime after that. So the assessment serves to quantify the obligation. It doesn't establish a new liability. That's the important principle coming through this judgment. The timing of the SARS assessment, in this case, the assessment was raised post-commencement, all right, but it did not change the nature of the debt. The debt arose pre-commencement. That was the finding of the SCA. All right, and the judgment also highlights statutory provisions in terms of Section 154 of the Companies Act, which clearly prohibits the enforcement of debts incurred before the commencement of business rescue, unless and apart from what's outlined in the business rescue plan. All right, so it is an important judgment, I think, especially for companies in business rescue, and just around this principle of when does a tax debt actually come into existence. There are other aspects around business rescue that still are creating a lot of problems in practice, I think, especially, you know, you might have clawback of VAT, input tax, for example, that has been claimed in the past and now has to be clawed back because the amount hasn't been paid. And the question is, when does that, what is the timing of that? Is it pre or post? They do talk about that also being triggered by transactions, but I think when you have clawback issues and adjustments, it gets more complex. All right. So set off is permitted, but in the case of a business rescue situation, you can't set off pre-commencement against post-commencement. That is just not possible. You can't mix the two. All right, and that is basically the conclusion of the SCA. So it brings us in at a good time to take a break. And being 15:38, probably just about to go to 15:39, is probably appropriate to take a break until 15:55. So I wonder, Danny, if you could just maybe put a notice up to say we're having a break until 15:55, and I will see you back then for the rest of the webinar. Right, everybody, are you ready to carry on for the second session? All right, so let's carry on then. Just check that my sound is, yeah, make sure I'm not muted. It's always a good thing, right? Okay, so let's go on to the next one. So the next case is JMAT Enviro Solutions. And just an interesting one here, especially now that you're in your EMP 501 reconciliation phase, or you've probably finished now because the due date is really tomorrow. It's the 31st of May, but the 31st is on Saturday. So yeah, it's one of the things coming up in the SARS notices later, just to remind you about the EMP 501 deadline. But in this particular case, the taxpayer was looking at claiming ETI credits. Now, as you know, ETI credits, employment tax incentive credits, are claimed against your employee's tax that you have to pay over to SARS. And in this case, the taxpayer had done their submission, done their reconciliation, and then realized that actually they were entitled to a whole lot more credits than what they had actually claimed. And so they then went and did a revised EMP 501 reconciliation, but SARS didn't process the revised. And so they then wanted to bring the necessary legal instruction to ensure SARS would actually go ahead and process. They had gone back and forth a number of times, but SARS just refused to process the additional ETI credits. And so the taxpayer then took the matter on judicial review, Section 6 and Section 7 of PARJA. You'll see here it talks about the 180-day period. But if we just take a step back, Section 6 of PARJA enables taxpayers to seek judicial review on various grounds like lack of authority or an unfair action, a procedurally unfair action, or failure to take a decision. And the taxpayer was saying here SARS was failing to process these additional ETI credits. And that was procedurally unfair. And so they were bringing this application for review. Now, Section 7, linking to Section 6, then introduces this 180-day period. So it stipulates that if you are bringing an application for review, a judicial review, it must be initiated within 180 days from the date on which the taxpayer was informed of the administrative action or might reasonably have been expected to have been aware of the action and the decisions. Now, in this particular case, the question was, on the one hand, when did that 180-day period begin to run? And when should the taxpayer have known SARS' reason for not processing those credits? The application for review, the court actually rejected and said, well, the taxpayer should have followed the normal dispute resolution process. Now, yeah, I mean, possibly, but it would be quite difficult. In terms of the PARJA, Section 7(1)(b), it says the applicant was made aware of SARS' reasons in their decision in correspondence on the 16th of May, and their position remained unchanged, even though there was subsequent correspondence. And we've seen this before. The subsequent correspondence doesn't mark the starting date of that 180-day period if that story doesn't change. If the subsequent correspondence just confirms what was communicated previously, then the 180 days starts from the original correspondence. Okay, so here it actually came to the conclusion that the taxpayer had gone beyond the 180-day period, and so the application was dismissed. But it is quite important to take note with the ETI, and maybe I'll just pause there for a moment and just remind you that with the ETI, yes, you claim the ETI credit against your PAYE that you have to pay over to SARS. And you do that on your EMP submissions, and you then have to disclose on your EMP 501. But now remember that the EMP 501 is a 6-monthly reconciliation. And it's crucially important to bear in mind that when you do that 6-monthly reconciliation, you are closing off that 6-month period. Okay, and even SARS guide on the EMP 501 reconciliation process, I'm actually reading here from one of their paragraphs in that guide. It says, where the ETI was undercalculated, such as happened here, the taxpayer wanted to claim extra ETI, they say the pre-populated values remain unchanged. An employer may only claim ETI up to the last month within the 6-month tax period. And where the ETI is not being claimed on the EMP 201 by the due date of the last period, the ETI is forfeited. So when you submit your EMP 501, you're wrapping everything up, closing it off. You cannot then change those amounts. And that's the point that was coming through here. And that comes through Section 9 of the ETI Act, which allows credits to be rolled over from month to month within that 6-month period. But then when you get to the end of the 6-month period and you do your reconciliation, it closes it off and you can't carry amounts or roll amounts over into the next 6-month period. All right, and so SARS makes the point that any claim missed after the closing period is forfeited. And so I think the key thing here is just to bear in mind, especially while you're doing your EMP 501s, to make really 100% sure that the ETI that you're showing on your EMP 501 is 100% accurate before you submit the EMP 501 reconciliation. You can't think of this, doing a request for correction and things like that. There are other areas where you can do request for correction, but this is not one of them. SARS makes the point in their guide that once the EMP 501 submission is finalized, it's binding. And the only way you could actually change anything is actually go on to an objection process where you're actually objecting against that assessment, albeit that that's kind of a self-assessment in that situation. And so that's why the court was saying here that the taxpayer should have made use of the normal dispute resolution process rather than looking for a judicial review. All right, so crucially important to make sure that you're claiming the ETI legitimately, that you are claiming the correct amount when you do your EMP 501 reconciliation. And if you ever make use of the dispute resolution process and you're going on a PARJA review, be very careful of that 180-day deadline. Okay, so I think those are the important aspects that came out of that judgment. All right, and then, another one with the Section 105 review, Aspasa. And this was quite an interesting one. Again, kind of cutting into the mining fraternity, but this is an interesting one because it was actually, the whole process here just is, interesting to see it playing out. And what had happened here is that the taxpayers, in fact, Aspasa NPC is a non-profit, as the name indicates, and it represents your small miners. And then, of course, there's a whole host of others in this judgment. In fact, there were 11 parties. Others represents 11 people who are all in this kind of mining industry. And they wanted a declarator in terms of the interpretation of a certain term. So it's quite interesting to see how that comes through in terms of the application of Section 105. All right, so they applied for the High Court to have jurisdiction to adjudicate on the application. And the declarator they wanted is to have a declaration that this term bulk meant a certain thing. Now, we're not going to get into all the ins and outs of how this all happens, but what I want to focus on is the process. That is what is important here. So this application for a declarator around the interpretation of a certain term. Now, these parties had been in a bit of a conflict, but now here's another situation where no assessment had been issued yet, all right? And so they say here in the judgment, despite the absence of a decision or an assessment, because this is the case where these taxpayers were anticipating that SARS was going to assess them in a certain way, because SARS had taken a view on the interpretation of this term bulk, which basically establishes the basis on which the mineral royalty is going to be calculated. And SARS was saying it is one thing, and the taxpayers were saying it is something else. All right. So it came down to this matter of interpretation. But there was quite a long saga behind this, because this particular industry had been interacting with SARS, and they had actually, the industry itself had gone and paid money to get a legal opinion on the interpretation of this term. They got an industry practice note that set out a legal opinion, and SARS seemed to buy into that, and they seemed to be in agreement with that particular interpretation. And then suddenly, out of the blue, that note was put together in 2009, although in draft form, all right? But then suddenly, out of the blue, SARS came up with an interpretation note in 2019, which took a different view on the interpretation of this particular term. So the basis on which they would be levying that minerals royalty would be different based on their different view. And so the taxpayers were saying, we can anticipate that SARS is going to assess us according to their interpretation, but we don't agree with it. And we've got very legitimate grounds for saying the interpretation should be this. And that's what they were applying to the court for, was this declarator, to agree with their interpretation. So although there was no assessment that had been issued, they said here that the motivation of an envisaged assessment is what is the motivation for the application. And so the default position is that the tax court should hear the application unless there are exceptional circumstances. Okay, the date of this judgment was before the Constitutional Court judgment, so they were still talking about exceptional circumstances for the Section 105 application. All right, but nonetheless, remember, exceptional circumstances at that stage could involve a pure matter of law. All right, so they were saying if there's exceptional circumstances, the High Court might intervene and issue their direction. And they said the High Court has jurisdiction to decide any dispute unless expressly ousted, and Section 105 is an ouster unless you get a direction, the approval of the High Court to say, yes, you may come and bring your application. And they said they're satisfied that, in fact, this application is appropriate and it falls within the circumstances when the High Court can hear the application, which would otherwise go the normal dispute resolution rule. But now you can imagine, for all of these parties, 11 or 12 parties, and plus there's a whole industry behind this, if they all waited for SARS to issue the assessments based on SARS interpretation when they have very good grounds for taking a different interpretation, I mean, this would cause, massive practical delays, costs, etc., across the whole industry. And so no doubt that was a motivator in terms of why they felt that this was a circumstance where the High Court could intervene and bring a ruling effectively as to what that interpretation should be. There was a need for clarity in the industry. So this interpretation of this word bulk affects the whole industry, and so it would be appropriate for the High Court to intervene. The tax court cannot issue a declaratory order, and that's important, an important principle. They can't issue this declaratory order because the tax court operates on a taxpayer by taxpayer basis. But what they were seeking from the High Court was a declaratory order that would affect the whole industry. All right. So basically, at the end of the day, they came to the conclusion that it was an application that could be considered by the High Court, and the High Court actually ended up considering the application and then ruling in favor of the taxpayer and basically instructing SARS that the interpretation was along the lines of the industry practice note that the taxpayers had obtained, that the industry had obtained back in 2009. All right. And so, it has been hailed as a well-reasoned and useful judgment. And looking at the application of Section 105, although we've got the Constitutional Court judgment that's come through since this one, but these all build together into a very important framework and foundations around the application of Section 105. All right. So, and also good to know that it was possible for the industry to go to the High Court and get clarity in this case, where an interpretation of a particular term was crucially important for the industry. Okay, so quite an interesting approach there. And then I think onto our last case of Suku and another, and this one going to preservation orders, and we again linking to what I was saying earlier about SARS being on the warpath for tax collections. I think that it is quite likely that we'll see preservation orders coming into play. I mean, we already see them, but probably even more. And so it's just an important aspect to have a look at a preservation order and what is the scope of a preservation order. Because a preservation order is taken out in terms of Section 163 of the Tax Administration Act, and it applies to the debts at the time that the order is granted. In this particular case, the order was granted, and it was quite a complex thing involving different companies and so on. But then there was a subsequent tax debt that arose. And the question was whether this preservation order could cover that subsequent tax debt. So it looks at the scope can the scope extend beyond the original purpose being the tax debt at the time? So we had this company, Kagiso, obtained a tender to supply protective equipment during the COVID pandemic, and it was to SAPS, South African Police Service, and they received 134 million rand for this. I mean, yeah, just another example of some of these transactions that were happening during the COVID-19 era. And so this 134 million rand was paid from SAPS to Kagiso, but they immediately transferred the full amount to shareholder and another company, Suku and his company, and they failed to declare anything for VAT or income tax. Now, SARS estimated that there's a probable tax liability, but they hadn't dug in and unearthed everything. They didn't know for sure, but they thought there's probably about 86 million tax liability there. And they took out a preservation order to prevent the realizable assets or any other person of the applicants or any other person against whom the probable tax liability may be collected. They stated that the basis of the application was that after Kagiso Africa had transferred the funds, the remaining balances were insufficient to meet the probable tax liability. So they took out the preservation order, all right, which was provisionally granted in 21 and then confirmed on the 16th of January 23. So just take note of those dates there. But then SARS had a look and did an audit, and they did raise income tax and VAT assessments. Now, coming back not to Kagiso, but to this other company of Suku's, which was called Spirit of African Market. They raised this, that was the second applicant, and they raised tax assessments on that applicant, okay? And SARS alleged that the same preservation order applied to the assets of the second applicant. Notice here that the tax case was Suku, let me just go back here, Suku and another. It was actually Suku, and this other was Spirit of African Markets Pty Limited, a company of which Mr. Suku was the director and shareholder. Okay, so it was basically his company. So basically that company, his company, had this tax liability that arose, and SARS said the same preservation order covers it, but the applicants contended that these liabilities fell outside the scope of the original preservation order. And it was agreed that this second applicant, Suku's company, did not owe SARS any debt in respect of the Kagiso transaction. SARS still argued that the preservation order was necessary, etc., etc. But at the end of the day, if you look at section 183, it talks about the debt that is in existence when you take out the preservation order. We're not going to go through all the wording there. So it envisages when a preservation order may be sought, when the full amount of tax is due and payable, which entails when the amount is known, or when, and this is what we saw in Kagiso's case, an official on reasonable grounds is satisfied that the full amount may become due and payable. But nonetheless, so that establishes that, yes, the original preservation order, all well and good, but the scope of that preservation order was around the assets of Kagiso. And the fact that the money was transferred to Mr. Suku and his company, SARS came to the conclusion that the company didn't have any other liability linked to this 134 million rand. There was other tax liability that arose, and so that was outside the scope of the original preservation order that had been raised. Okay, so yeah, just an interesting one there in terms of the scope of a preservation order. And again, important for taxpayers to know their rights and to exercise their rights. In this case, the taxpayer was successful. The court said that the preservation order issued in 23 was no longer in force, all right? Because that was for a tax debt that existed then. There's no longer that tax debt. This is now another tax debt, so that preservation order doesn't apply. And the first respondent, which is SARS, was ordered to pay the costs of the application, including the costs of counsel on scale C. All right, so just an interesting one in terms of the preservation orders. Right, now you'll be pleased to know we're going to move on to something other than another tax case at this stage. We're going to look at the SARS documents and notices. And as I say, not too much going on in the SARS stable, other than all the usual things, you know, with the EMP 501s and so on. But they have issued 2 new interpretation notes, 137 and 138. 138, I don't think will apply to many of you. It's dealing with the mining industry again, the mining royalty, and looking at what they say, the calorific value of coal. Some people who are on diet might look at that and think calorific value means certain things from a dieting perspective, but no, this is for the minerals royalty, okay? And then IN 137 talks about recoupment of amounts deducted or set off when an asset commences to be held as trading stock. And I think just an important aspect here, just remember that when you change the use of an asset, whether it be a capital asset becoming trading stock or vice versa, that does trigger tax events, like it could be recoupments, capital gains tax, and one has to think about all these different aspects. So if you do have a change of use, have a look at interpretation note 137. Sorry, this is jumping a little bit. And then IN 20, an old interpretation note, but now been updated, issue number 9, dealing with the learnership agreements. Okay, this is just really updating for the recent changes. In fact, it was the sunset date that was extended for the learnership agreements, all right, under section 12H. So yeah, IN 20 has just been updated to reflect that new sunset date. Okay, and then there's a whole lot of guides and so on that SARS has issued around the employer filing season, which, as I said, the deadline is 31 May, so that's almost upon us. But you can go onto the SARS website, even if you just copy the title and put it into Google, it'll come up with these, because I think you don't have the live links on your slides, but I'll just click on here so that you can see where this is coming from. You'll see from SARS, types of tax, etc. And then you go on to PAYE and you'll find all of the information around the employer filing season, but it's nearly finished now. Of course, what isn't nearly finished, what's just opening up, is the ITR 14s for 2025. And so there are issues around beneficial interest, beneficial ownership registers, etc. And so the disclosure requirements around that on the ITR 14, please have a look at the updated guide, which is available on the SARS website. Transfer duty, remember that the thresholds for transfer duty changed on the 1st of April, as announced in Budget Speech version 1. And so, yeah, just be aware of that. But then also SARS has updated their guide on transfer duty, especially using e-filing. So there's the link to that. You'll see it comes through. I'm actually opening it for you there. So the guide for transfer duty via e-filing, and it goes through how to submit your declarations and make your payments, etc. Okay. Right, and then there's the frequently asked questions around some of the VAT regulations that have been updated recently, and this is the yes.
There's a question. What's the deadline for the return specifically for trusts?
I'll come to that in a moment. I'll come to the deadlines in a moment. Yeah, thank you. Yeah, so these frequently asked questions on the domestic reverse charge regulations and electronic services, these regulations affecting VAT were updated recently. So yeah, some FAQs on that. Right, and then let's go on to the next one, which talks about the filing season. All right, for the actual tax returns, okay, so section 25 of the, and I'm just going to, thanks George, I'm going to just cancel that because I'm going to talk about this now. Section 25 of the Tax Administration Act tells us who has to submit tax returns, and Section 66 of the Income Tax Act and Section 25 of the Tax Administration Act are linked. So what happens is that every year the Commissioner has to publish this notice in the Government Gazette, which tells us who has to submit tax returns, okay? And so the notice for this year's filing season was published on the 23rd of May, 2025, so last Friday. So this is hot off the press, and here's the actual Gazette. And so, yeah, every year we have to wait for this Gazette to tell us who has to submit returns. The good news is that there's actually basically no change from last year, except for the submission dates. Yeah, obviously, because they've got to be very specific. But if we go through who has to submit for the 2025 year of assessment, Essentially, it's exactly the same as we saw for last year. So companies that were residents during the 25-year, if they had gross income, assets, liabilities, capital gain or loss of more than 1,000 rand, okay, then you have to submit gross income, all right, not taxable income, gross income. So it might be a company that received dividends of 1,200 rand. Maybe all those dividends are tax exempt, but you still have to submit a tax return. And it's really important to make sure that you know who has to submit a tax return, because as we know, SARS is very much on the bandwagon to raise non-compliance penalties for failure to submit returns. And this can really catch up with people quite badly, especially when you've had people who maybe have left the country some years ago and they just decided that they're not going to submit tax returns anymore. And now they realize actually, SARS has not forgotten about them, and it could become a bit of a problem. Anyway, so companies that are resident, any trust that was a resident, so any trust that was a resident, regardless of whatever income you've got coming through that trust, it simply says every trust that was a resident during the year has to submit a tax return. Okay, if it's a non-resident, there's certain rules there. Natural persons, if you carried on trade, if you're not a resident and you carried on trade in the Republic. Of course, there are certain exclusions for natural persons. If you earned only remuneration from one employer and the correct employee's tax was withheld, and you had no allowances, no fringe benefits, and no foreign remuneration, then you don't have to submit. Okay, but otherwise, all the rules are set out in here as to who has to submit returns. Okay, so crucially important that you are aware of who has to submit a tax return. Okay, then of course the submission dates, and let's just go down here. So the submission dates, companies again 12 months from the end of the financial year. Trusts, okay, notice here, any trust, if the return relates to a trust, the deadline is 19 January 2026. Okay, if it's an individual or an institution, board or body other than a company or a PBO or a recreational club, then your deadline is 20 October 25, all right? Or if you're a provisional taxpayer, as a natural person, etc., who's a provisional taxpayer, your deadline is 19 January 26. All right, so the key dates are 20 October 2025 and 19 January 2026. So as I say, it's just like one day out from what it was last year, because I think that runs through to the Friday. Okay, so yeah, please do take note of this notice, and yeah, just be very careful. I just want to just quickly talk about, even non-residents, in many cases have to still submit returns, okay? Because if you talk about an individual, let's go down to a natural person who's not a resident. If they carried on any trade in the Republic, all right, they would have to submit a tax return. And if they basically earn South African source income, they would have to look at submitting tax returns. And look here, every non-resident whose gross income included interest from a source in the Republic, which is not exempt under 10(1)H, which is the specific non-resident interest exemption, they would have to submit a tax return. Yeah, so it does get quite complex. I always get a bit nervous when I see these 3-line publications in the media around these are the people who don't have to submit returns, because it's actually, there's all sorts of terms and conditions that apply around who has to submit and who doesn't have to submit. Okay, so the best is to just look at the original document, which is this Government Gazette, and make sure that you're 100% familiar with who does have to submit and also what the deadline date is for that submission. Okay, all right, so that's that notice over there, and I think that pretty much brings us to the end. Just the last bit is on the SARS interest rates. So as I mentioned earlier, I just got this pop-up on my phone to say that the Reserve Bank has dropped the repo rate by 25 basis points. So as we have it at the moment, the Reserve Bank repo rate is 7.5%. It has been since the 31st of January up to the 29th of May, and now it's going to drop, I think, from tomorrow. The prime overdraft rate is 11%, which is the same as this rate, the SARS charges, all right? And then the interest that's paid by SARS if you've got a overpayment of tax, and if you're lucky enough to get interest paid to you, then they'll pay it at this rate over here. So that's interest coming to you, interest paid by you to SARS. And then we've got the official rate of interest, and that's the one that's used as the benchmark when you're calculating fringe benefit value on a low interest loan advance to an employee, when you've got deemed dividends, right, or deemed donation under Section 7C. We always say, what is the amount of interest on that loan versus the SARS official rate of interest? Okay, so if you've got if you're charging interest below the official rate of interest in those cases, then you end up with a deemed dividend, deemed donation, etc., etc. Okay, so this is the SARS official rate of interest. So when we see an interest rate changing, like this one, when it changed on the 31st of January, it dropped by 25 basis points there. Then you'll see that 25 basis point drop carries through to the official rate of interest the first day of the following month. So there you see it dropped from 8.75 to 8.5. But with these other rates, Table 1 and Table 2, interest paid to and by SARS, that 25 basis point only kicked in sort of 4 months later. Okay, so you'll see here, 1st of May, we saw that drop coming in. So what we're going to see now, this other 25 basis point, it'll affect the official rate of interest from the 1st of June, but it'll only affect Table 1 and Table 2 interest the first day of the 4th month thereafter. Okay, now what is also interesting is, of course, we've had a period where interest rates were quite high, and sort of in recent times they've kind of dropped a little bit. But what that's meant is that when you think about it in terms of this official interest rate that's used for deemed dividends, deemed donations, and so on, if the interest rate is very high, then it's going to result in high deemed dividends, etc. And if you look at the average interest rate, this is looking at the official interest rate. Well, it's looking at the SARB rate, Table 1, Table 2, Table 3. Table 3 is your official interest rate. This is the average over the year ended Feb 22, 23, 24, 25. Okay, so if you just look at the movement in the interest rates during the year, what is the average rate over the year? Now, as you'll see, if we look at the official rate of interest in Table 3, it was really low in 2022, 4.58. Over this last year, up to the end of Feb 25, the average rate was 9.06. It's almost double, okay, what it was in 22. It's a little bit lower than last year. Last year was 9.08. So if you were doing a calculation on a 10 million Rand interest-free loan and you were saying, what is my deemed donation for purposes of Section 7C? All right, you'd say, what is the interest charged on this loan? Well, nothing, because it's interest-free, minus what would the interest have been if you were using SARS official rate. So that's the interest differential. Now, in 2022, that would have given you a deemed donation based on this 4.58% of 458,000. In 24, that would have translated to 908,000 deemed donation. And of course, in 25, based on the slightly reduced rate of 9.06, it comes 906,250. So it's kind of similar to last year, but a lot higher than it was 2022 and prior years. All right. So just a point to note there with your deemed dividends, deemed donations, when the interest rates are high, it's creating more exposure for tax liability on those loans for your deemed dividends, deemed donations, and your employees' low interest loans as well. Okay, and that's all I wanted to say about the interest rates. So I don't know if anybody has any other questions that you want to ask. We are just on 4:30. We have a bit of time, but I won't keep you here unnecessarily because I think you probably are feeling a bit overloaded with information at this stage anyway, because we've been through a lot today. But just to say thank you so much for joining me, and I'm going to hand back to Stan and Danny. But if there's any other questions that come through, we will address them. But from me, thank you very much and goodbye.
So, Jackie, as usual, good afternoon, very well prepared, very well presented. Leave no doubts in people's minds, I'm sure. I'd be surprised if I find any questions, but I see these two. You want to those?
It's people saying thank you so far.
Thank you. Yes, I see that.
Yeah.
Oh, thank you.
Yeah.
Well, you're most welcome. Thank you.
So they're giving the answer before the question. Okay. So again, thank you everybody for joining us. We're on their way shortly. And we do have 2 upcoming webinars in the next 2 months, one on exchange control in June and one on estates in July. And you will be notified in the next week or so. And so really this afternoon, I don't know if anybody wants to venture into mining because it seems you have a lot of money for legal costs set aside. But that you hope everybody has the rest of the afternoon enjoys that. Bye.
Good. Thanks very much, everybody. Goodbye.
Thank you again, Jackie.
Thank you. Bye.
Bye.
Bye.